Welcome to Chapter 2, in which we will be discussing the history of EMS law. When completed with this presentation, you should be able to discuss how EMS law affects the individual, examine the white paper and understand how the principles contained therein apply to today's EMS system, understand how the National Highway Transportation Act has shaped the development of EMS, explain COBRA and its purpose, comprehend EMTALA and how it affects EMS services, and identify how the KKK ambulance specifications were developed with future application of NFPA guidelines. To begin this chapter, let's consider the following scenario. One of your paramedic crews approaches you with a complaint about one of your community's receiving facilities. The crew delivered a young woman with acute abdominal pain to the ED. When the crew arrived, they were told to just stand aside until someone could get to them. One of the paramedics told the nurse that the patient was in a lot of pain, to which the nurse responded, "Everyone here is in pain." While waiting for the ED to take the report and assume patient care, dispatch called the crew numerous times to check their status as other emergency calls were coming in. After waiting with the patient approximately 45 minutes in the ED triage area, the patient's level of consciousness began to drop, along with her already low blood pressure. The crew was finally able to attract the attention of a physician who was concerned that the woman may be suffering from an ectopic pregnancy and related internal bleeding. At this point, the EMS crew is asking you, as their supervisor, if they have any legal culpability if the patient has a negative outcome due to the extended wait in the ED. The situation described is, unfortunately, becoming more common as hospital emergency rooms see increased volume every year. According to the National Hospital Ambulatory Medical Care Survey, as cited by the United States Centers for Disease Control, there were over 136.3 million ED visits in 2011, with 40.7% of those patients waiting anywhere from 15 to 59 minutes to be seen by a physician, physician's assistant, or a nurse practitioner. Only 27% were seen within 15 minutes of arrival. The Wall Street Journal reported in May of 2015 that ED visits have increased significantly since the Patient Protection and Affordable Care Act was passed, and handover delays have become so much of an issue that the National Association of EMS Physicians published a position statement on the subject. In 2012, the state of California determined that one county service lost 17,345 hours in the handoff process at just one hospital with an approximate cost of $2.6 million. As these delays become longer and more common, one may wonder if there are any laws that prevent this type of issue. Did the ED violate EMTALA? What liability does the crew have if such a delay causes a negative patient outcome? As a system manager, is there anything you can or should do about it? Keep these questions in mind as we proceed through this chapter, as these issues, and many more, will be discussed. To expand upon our history lesson from last chapter, EMS has its roots all the way back to 1500 BC, when Good Samaritans would use oil and wine to help bind the wounds of others. More recently, in 1797, the chief physician in Napoleon's army created a system of triage and transport. Within the United States itself, field care and transport of the injured really began during the Civil War. EMS really saw significant development in the 1950s and 60s as the United States applied field care and transport protocols in the Korean and Vietnam Wars, and then started applying that type of care within the country through civilian services. CPR started to emerge in the 1960s, along with field cardiac care, firefighters being trained in resuscitation, and the development of the chain of survival that we recognize today. As EMS continued to develop, the laws governing the practice of field medicine needed to evolve as well. Ultimately, the laws that apply to EMS services and providers routinely try to strike a balance between protecting the EMS agency and provider from liability for providing a necessary service, while also ensuring quality of care to protect the patient. The law as it applies to EMS providers is so important that the national education standards for EMS programs at all levels, from EMR up to paramedic, require information on the legal aspects of EMS care. Whether an EMS provider is a paid, full-time employee or a volunteer receiving no compensation, it is important to understand the laws that apply and the consequences for failing to follow them. Ultimately, ignorance of the law is no excuse, and those laws will still be applied even if the EMS provider was unaware of them. As a result, it is important to be familiar with the laws that impact how we provide EMS services, especially as a manager and leader within an EMS organization, as those individuals shoulder even more responsibility for the care provided to patients in the field. To begin this discussion about EMS law, we will start with the civil tort of negligence. While negligence will be discussed in much greater depth later in this course, an overview here should prove beneficial. Within this particular slide, the textbook author states that gross negligence is commonly required before an EMS provider could be sued by a patient or family. To clarify this point, anyone can sue whether negligence, gross or otherwise, existed or not. Beyond that, the term gross negligence has a very specific meaning within the law, and it is debatable whether or not gross negligence is the threshold for finding an EMS provider liable for civil damages to a patient. In many instances, the difference may lie in how liability is defined by law within the respective state. For the time being, though, a quick overview of negligence should suffice until it is discussed further in the subsequent chapter within the textbook. Negligence is a very important topic to understand because it is the legal doctrine under which EMS providers probably have the most exposure to liability. Simply stated, an EMS provider is negligent if he or she fails to act reasonably and causes harm to a person to whom the EMS provider owed a legal duty. Generally, when determining the reasonableness of an individual's actions, the jury is asked to determine what a reasonably prudent person would do in the same or similar circumstances. When a professional is involved, however, the threshold is elevated to that of what a reasonably prudent person with the same level of knowledge, training, and experience would do under the same or similar circumstances. This is often referred to as the reasonably prudent professional standard. Do not be misled by the word professional, though, as even a volunteer will be held to this standard by virtue of his or her formal education, training, and experience. Therefore, negligence can occur if an EMS provider does something that a reasonably prudent EMT or paramedic would not have done under the same or similar circumstances. Inversely, if the EMS provider fails to do something that the reasonably prudent EMT or paramedic would have done, that can also give rise to negligence. Failing to conduct a thorough assessment, performing an intervention incorrectly, or failing to maintain equipment are all simple examples of events that could give rise to civil liability in negligence. Negligence is commonly recognized to consist of four elements: duty to act, breach of duty, causation, and damages. Some legal scholars may divide these up a little differently and may actually consider defenses to negligence in their analysis. For the EMS provider, however, understanding these four elements is more than adequate to define negligent behavior. With these elements in mind, in order to be found negligent, an EMS provider must first owe a duty to someone, such as the patient. There must be a breach of that duty, which could occur if the EMS provider failed to follow established protocols or a recognized standard of care. The provider failed to act as a reasonably prudent EMT or paramedic in the same or similar circumstances. The patient or plaintiff must have suffered damages, and it must have been the actions of the EMS provider, or lack thereof, that caused those damages. That, in a nutshell, is how negligence is defined. Again, we will talk about negligence in much greater depth later within this course. As far as the history of EMS and EMS law is concerned, a significant milestone occurred in 1966 when the National Academy of Sciences published Accidental Death and Disability, the Neglected Disease of Modern Society. Simply referred to as the White Paper, this document really brought awareness to the need for pre-hospital care to legislators and the public. The document identified trauma as the leading cause of death among young Americans, and that we, as a country, really lack the ability to provide adequate care to this segment of the population. Within this discussion, the White Paper outlined 29 recommendations to improve care and outcome for trauma patients. The White Paper also set the stage for further study and research, was the impetus for some federal funding to help establish EMS systems around the country, and ultimately paved the way for EMS as we know it today. With the White Paper playing a part, the United States Congress passed the Highway Safety Act of 1966. This act established the United States Department of Transportation, and one of the goals of the DOT was to address the public concern of rising numbers of traffic fatalities in children and young adults. Within its mandate, the DOT was tasked with improving EMS through system elements that we take for granted today, such as training and education, communications, facilities, vehicles, public safety agencies, access to care, patient transfer, record keeping, public information, mutual aid, and disaster planning. While EMS now deals with much more than just vehicle collisions and trauma, the involvement of the U.S. DOT in the nationwide implementation and management of EMS systems is still significant and ongoing. With the involvement of the U.S. Department of Transportation and its child organization, the National Highway Transportation Safety Administration, a national standard curriculum for EMS education was released in 1969, with several iterations to follow over the years for different recognized levels of EMS, from first responder to paramedic. States were also provided with federal funds to develop their own regional EMS systems. The DOT and its agencies, namely NHTSA, are still involved in EMS today. Through NHTSA's EMS.gov website, anyone can review the Education Agenda for the Future, National EMS Education Standards, Instructional Guidelines, the EMS Agenda for the Future, the EMS Research Agenda, and other important resources. Information on important EMS initiatives such as education, data tracking, advancing EMS systems, preparedness, research, safety, workforce development, and 911 systems are really available through NHTSA's EMS.gov website as well. If you have not visited the EMS.gov website before, you are highly encouraged to do so. There's a lot of information and numerous resources on that site related to EMS initiatives and activities at the national level, which tends to filter down to the states and the local level. In addition to these resources, NHTSA also writes and enforces federal motor vehicle safety standards, develops test dummies and test protocols, maintains data files related to trauma, such as the Fatality Analysis Reporting System, provides research, investigates defects, and enforces safety standards for the goal of preventing injury and preserving life, and it also provides public education. Beyond the DOT and NHTSA, the white paper also had an impact on other laws that affect patient care within the country. One such law is the Emergency Medical Treatment and Active Labor Act, referred to as EMTALA. This law was passed as part of the Consolidated Omnibus Budget Reconciliation Act of 1986 and modified the Social Security Act to protect patients from abandonment regardless of their ability to pay for medical services. The law governs when and how an unstable medical patient may be refused treatment or transferred from one hospital to another. If you remember back to the first chapter, the federal government cannot necessarily regulate for the safety, health, and well-being of the general public. That is a state function. The way in which the federal government applies EMTALA is by tying compliance to federal funds. If a hospital accepts Medicare or Medicaid funding, the provisions of EMTALA apply, and hospitals that provide emergency services cannot refuse service to someone because of an inability to pay for treatment. Believe it or not, prior to EMTALA, it was somewhat common practice for hospitals to refuse patients who lacked the financial means to pay for services. Under EMTALA, hospitals no longer have that choice. Now, under EMTALA, hospitals must treat all patients the same, regardless of their ability to pay. A medical screening must be performed on all patients to determine if the patient is suffering from an emergency medical condition or is in active labor. If either exists, the hospital must treat the patient or, if the hospital lacks the ability to provide adequate care, adequately stabilize the patient and transfer him or her to another appropriate hospital. From an EMS standpoint, once the patient is en route to the hospital and the emergency department has been notified, the patient is covered by EMTALA. This ties into diversions, which are becoming more and more common as emergency room visits continue to climb. Hospital emergency departments often reach capacity and ambulances are diverted to other nearby facilities. Under EMTALA, however, if the patient is critical, the ambulance cannot be diverted away. The hospital is obligated to treat and stabilize the patient before transferring him or her to another facility. Thinking back to the scenario at the beginning of this presentation, you may already be wondering how EMTALA relates to patient handoff delays at the hospital. As previously mentioned, this has become such a problem that the Center for Medicare and Medicaid Services issued letters in 2006 and 2007 to clarify that this issue of patient parking can result in an EMTALA violation. When a hospital fails to accept a patient in a timely manner and, subsequently, fails to release the EMS crew, this can jeopardize the patient's health and also impacts the ability of the EMS agency to provide care to other patients who may need their assistance. The hospital staff may ask the EMS crew to stay with the person they transported if the hospital does not have the capacity or capability to immediately assume full responsibility for the patient, but the hospital must immediately triage the patient's condition to ensure the patient is not experiencing a true medical emergency. The hospital must also ensure the EMS crew can continue to appropriately monitor the patient's condition. Even if the EMS crew remains with the patient, however, the hospital's duty under EMTALA is not waived. As a matter of fact, that duty begins as soon as the ambulance arrives on the hospital grounds. Under EMTALA, the hospital actually has a duty to provide medical screening or emergency treatment to anyone within 250 yards of their main buildings. A noted exception to this duty, though, is when an ambulance service uses the hospital's helipad for a patient evacuation. So long as the hospital with the helipad is not the receiving facility, the hospital owes no duty to the patient under EMTALA. If, for whatever reason, the patient needs to be diverted to the hospital with the helipad, however, an EMTALA obligation will be created. The white paper even had an impact on other EMS-related laws and practices, such as record keeping and patient privacy. We'll discuss documentation and patient confidentiality requirements in greater depth later within this course. For the time being, though, keep in mind that the release of patient information must meet specific requirements to protect the patient's right to privacy. While patient care issues are commonly at the forefront of an EMS agency's considerations, it is also important to remember the need to ensure properly maintained medical equipment, beginning with the ambulance. Back in the 1970s, the General Services Administration of the federal government developed what is known as the Triple K standard for ambulance design and construction to be used by federal agencies when purchasing ambulances. With the lack of any consensus standard at the time, ambulance manufacturers adopted the Triple K standards for the design of their ambulances. Because technology has changed so much over time and the Triple K standard was developed back in the 1970s, the National Fire Protection Association developed its own standard for ambulances in 2013. Similar to all NFPA consensus standards, the technical committee included a broad assortment of key stakeholders, including fire department, ambulance service, and ambulance manufacturing representatives. These members met to develop a standard to improve ambulance crew and patient safety through higher levels of equipment, documentation, and testing. As with any change to a long-standing standard, the new guidelines include many elements that were never considered in the 1970s. Some of the new elements within NFPA 1917 include a data recorder with speed limiting technology, preventing ambulances from exceeding 77 miles per hour, maximum seat capacity, seatbelt monitoring systems, new payload requirements, tire pressure and battery testing requirements, carbon monoxide detectors in the patient compartment, warning lights in the cab if a door is open, load testing requirements, and training requirements for personnel. At the time this presentation was developed, however, there has been some considerable backlash to NFPA 1917 by EMS agencies as well as ambulance manufacturers. The new standards are considered very costly given the inclusion of new technology and crash testing requirements. Many EMS agencies are unhappy with limiting the speed of ambulances to 77 miles per hour, especially when many areas have interstates with a posted 70 mile per hour speed limit. Driving an ambulance red lights and siren at 77 miles per hour on these roadways may actually impede traffic and create a hazard that did not previously exist. Ambulance manufacturers are also concerned that, if the standard is not adopted by everyone, there could be variance from state to state, which could be problematic. Within Wisconsin, the DOT maintains an administrative rule, Trans 309, that governs the inspection of ambulances. This rule also includes standards for the ambulance vehicle itself, as well as the equipment carried within the ambulance. The state ambulance inspector is employed by the state patrol and travels around the state to inspect ambulances for roadworthiness and compliance with the provisions of Trans 309. The rule contains provisions regarding both vehicle and equipment standards. Interior dimensions of the patient compartment, tires, batteries, exterior lighting, communications, restraints, and required oxygen equipment are just some of the items covered within this rule. So, to wrap up this chapter, think back to the original scenario presented at the beginning of this presentation. We know that EMTALA applies in this situation, and neither the ambulance company nor its crew should be held liable for the delay in patient handoff. EMTALA requires the hospital to perform a medical screening to ensure the patient is not suffering from a critical condition. In this situation, the hospital failed to provide that screening, and it appears from the facts provided that the hospital failed to meet its responsibilities under EMTALA. Ultimately, responsibility and liability for any negative patient outcome as a result of the patient parking issue will fall on the hospital. In this instance, the hospital would have needed to ask the crew to stay with the patient only after triaging her condition. This is also an example of why documentation is so important. If there was a delay in patient handoff, it should have been documented on the patient care report. Additionally, it would not be a bad idea for the ambulance service to have an incident report separate from the patient care report to document such concerns on behalf of the ambulance crew. Ultimately, while the hospital should be liable in this instance, it will be important for the EMS crew and agency to be able to defend themselves years later in court if necessary. Documentation of this delay, along with the objective patient assessment and reassessment findings by the EMS crew, will be vital to defend against a subsequent legal claim by the patient or her family. To summarize this chapter, modern EMS saw its legal origins in 1966 as a result of the publication of the White Paper and its 29 recommendations to improve care and outcome for trauma patients. Shortly thereafter, the U.S. DOT and NHTSA were created to address some of these concerns, and additional laws such as EMTALA were passed to protect patients. EMS has changed drastically over the years since the White Paper was published. Technology has evolved, and comprehensive systems are now in place to provide quality EMS to patients in need. Some may argue that EMS still has a long way to go, which may be true, but we are in a much better position than we were in the late 60s and early 70s, and the system continues to evolve. As future leaders within the field of EMS, it will be your responsibility to continue moving the system forward to improve care and outcomes for our patients.